pleasant good day, and once again, welcome to Strictly Legal on WESN, Content Capital. I am your host, Rondell Donawa, and once again, I'm happy to bring the law and you. You can stream us on WESN, Content Capital, on all social media platforms, including the World Wide Web, and of course, our podcast, Strictly Legal with Rondell Donawa. This week, we have once again Mr. Farid Ali, attorney at law, continuing the discussion on citizens and your rights with respect to law enforcement. On the last occasion, we would have delved straight into the issue of stop and search, as well as many other issues in terms of whether or not someone can record a police officer, whether or not that is what you call obstruction of a police officer's duties, as well as many other areas in terms of your rights and responsibilities and the law enforcement. Of course, we would have touched on warrants, and then today we are going to continue our discussion on warrants because it's a large area, so that you, the citizens, can know, okay, what does the citizens, or rather, what does the police need to have in order to, whether it is to search your home, etc., and go further into that issue. So without further ado, I will welcome back again on set Mr. Farid Ali. Good morning.
Good morning, Mr. Donawa. It's a pleasure to be here.
Nice. So thank you for coming once again. I know I said that you look dashing, so thank you very much for being part of the coloring of the set, you know, the coordination.
I'm happy to assist in any way.
Right. So I know on the last occasion we would have discussed a wide range of police powers and, of course, what are the citizens' duties. Let's deal now with the warrant aspect of things. Let's get some context in terms of what is a warrant and what are the different types of warrants can be executed, etc.
Right. What we need to bear in mind is the issue of policing involves the police utilizing various tools in which to execute their function. A warrant is an instrument the police utilizes in order to enter somebody's premises. In other words, I cannot enter the premises of the Trinidad Express or the Trinidad Guardian or WESN and as a police officer randomly and arbitrarily. I have to have a reason in law or a reasonable basis in which to enter, and I must justify the need for me to enter. Now, when police officers are entering anybody's premises, that officer or those officers must be able to present to the owner of the household or the owner of the business place or the premises some document which is called a warrant, and that warrant speaks to exactly what is the reason that the police would need to enter the premises. Very often, it's a clear depiction. It shows that the reason could be that they have reason, meaning the police officers have reason to believe, based on information, that something of evidential value is contained on the compound, and that thing of evidential value is necessary for them to retrieve in order to assist the investigation into criminal activity that they're conducting. Now,
and let's an example. What sort of sort of evidence do they need?
A good example could be, and there's a very popular case, the one of Frankie Boudram versus the state. It's referred to commonly over the years as the Frankie Boudram judgment. This was a situation where in 2004, a young man went to the Queen's Park Oval to watch a cricket match, the West Indies play, and after he returned to his vehicle, he recognized at George V Park, it's gone. Eventually, the police, with their intelligence, had reason to believe that Speedway Auto Supplies in Samoa would have things of evidential value on their premises that speaks to where the van is. In other words, the police will review that the van was scrapped and that Speedway Auto Supplies Limited in Samoa contained the parts of the van. So they got a warrant, right, endorsed by a justice of the peace, which allowed officers Bruce and Gay to enter the compound in order to search to see if there's anything that touches and concerns the van or the remains of that van. So the warrant basically, and warrants on the whole, are for similar and like-minded things. If we want to use a more current example, quite recently, and I'm just referring to that by way of case law, there was a case involving the Media Group of Companies Limited, the Trinidad Express, and another defendant, the editor, Omotil Leader. That case was a 2021 judgment by Justice C. Prasad. Having said all of that, it was simple. Police officers had reason to believe that the Trinidad Express would have had information, data, in any form, which speaks to evidence of their being tipped off that one acting commissioner, Erwin Hackshaw, was being investigated for suspicious transactions where 15 individual deposits were made in different accounts between the years within the 2000s, let's put it that way instead of being more specific. The warrant was executed by one Wendell Lucas, and he went to the compound with 6 officers, produced the warrant, and was able to search the second floor of the Trinidad Express in order to retrieve items that they figure may have been of use to them. Basically, the suspicion was that the police, the TTPS, was of the view that in the newspaper, the articles that were carried on the 8th of March and the 10th of March 2020 replicated in print things that only persons who had access to special documents that only the police would have had in their possession could have replicated in the newspaper with such specificity. Indeed. Things written that they alone ought to have had. So the warrant was executed in order to try to retrieve those items that the Express seemed to have gotten from whatever source. And it was necessary because they were of the view that someone was tipping off if not Hackshaw, the Express, with regard to an investigation that was going on. And tipping off in itself is a crime under the Proceeds of Crime Act.
But can the newspaper use the defense of, let's say, public interest? I mean, I know at least in the civil proceedings, defamation, they use that point.
Right.
But an ongoing investigation. Right.
So this is where we get to. Every citizen in this country, and that applies not just to a citizen as an individual like you and myself, but a newspaper, a media house, those persons have a right under rights under Section 4 of the Constitution. So we may have the right to life, liberty, security of person, enjoyment of property. There's also an additional component where you have under Section 4K, freedom of the press, and Section 4I, freedom of thought and expression. So if there's a warrant has to be executed on a media house or at the Trinidad Express or any media personnel, it could be deemed a direct contravention of the fundamental right of freedom of the press and freedom of thought and expression in order to execute a warrant and seize items that may reveal who the source of these persons are. Yes. Because sources are important. The press and the media is a necessary tool in order to protect the democracy of any country, and particularly Trinidad and Tobago. So in allowing a warrant to be executed, we need to bear this in mind. A warrant is not a document that could be randomly and arbitrarily received. It must be constitutionally sound, meaning that it must not contravene these fundamental rights that I've referred to. It must also be lawful, it must be fair, and it must be proportionate. In other words, if it is you can extract that information without executing a warrant on somebody's premises, without contravening their rights, without in any way infringing on their individual rights, then that option ought to be exercised. So there's a criteria for getting a warrant, a criteria for deriving a warrant. And that criteria is grounded not just in case law, as I referred to the Frankie Boudram judgment, and I referred to the case involving the media house and the Express Limited. It involves reference to the Summary Courts Act, which is Section 41(1). And there's also the Preliminary Inquiry Indictable Offences Act, which refers to Section 5. Both of those elements are now committed to statute. Yes. So we are seeing in case law and in legislation, there's a clear depiction of how one should, the steps that one should take in order to execute a warrant and in order to get a warrant. Now, anytime a warrant has to be derived, the first thing that ought to be done is the police officer, on receiving the information, he ought to investigate whether there is truth to what is being said. So if Rondell Donawa says to me, a police officer, that he believes that there's illegal activity taking place in a business place on Gattaca Street, I can't just say, well, I hear a story, because that is hearsay. I have to now receive that hearsay or receive that report that is given to me, and I have to go now and do my own investigation and form an opinion factually whether there's any truth to what the information I've received. And if there is truth, I have to form a reasonable basis to believe not only that it is truth, but there's reason to believe that there is something of evidential value within the premises. When I get that, I swear on information before a justice of the peace. And the swearing on information is I'm indicating, number one, that the person's name is Rondell Donawa. He lives at this particular address, or he works at this particular address. We have been investigating concerning what appears to be some sort of criminal activity. We have reason to believe that there are guns and ammunition in the place, stolen items. So once he swears on oath before a justice of the peace, and the justice of the peace is satisfied that there is truth to what is being said, and he's satisfied that the officer seeking the warrant has done the due diligence, then that individual can now produce or issue a warrant, the justice of the peace, based on the information received. If that complaint upon oath, as we say, isn't made, then it's not constitutionally sound, or it doesn't satisfy the requirements of fairness, proportionality, lawfulness, or could you establish that it's constitutionally sound in order to issue the document? Now, what we found and what we have been seeing over the years is when warrants are executed and they are not properly derived or properly issued, the evidence can be challenged in the courtroom. So you may find criminals who may have committed an unlawful act, finding a loophole or a way to escape the arms of the law and escape justice, because the police did the right thing in the wrong manner.
But can the justice of the peace be challenged in the courts in terms of now having to be a witness for the improper execution of that warrant?
Well, the court has wide powers. If the court is of the belief that the justice of the peace erred or acted on information that was not sound enough, given the fact that the warrant turned out to infringe the rights of a citizen or a business, the court can simply give write to the DPP's office if they are of the view that a crime has been taking place and the justice of the peace was complicit in the commission of that offense, and have the DPP investigate the justice of the peace. Or the court may simply rule in relation to the matter before the court in favor of the defendant that it was a direct violation of his right, though the warrant was or may have been warranted, because the correct procedural steps wasn't taken in order to get it, to treat with what was received in a negative way.
So let's just bring some context to this. I know you would have stated previously that a warrant can only be executed on your personal dwelling. Is that correct?
No. The answer to that is yes, but no. A warrant may be executed on any compound, any carriage, vessel, vehicle, any dwelling house, any premises, if it is justified. If it is the police of the view that there are things of evidential value there. So if a man has items that are shared between his residence and his business, you can have separate warrants to be executed on separate compounds. If he has more than one residence, even if it is he lives in a bungalow, if it is believed it's stored in his vehicle, because you can't break and enter somebody's vehicle. I think what we also need to bear in mind is, and as we are talking about breaking and entering, when it is the warrant is presented to the household and the business, if it is the citizen looks at the warrant, there are certain features that ought to feature on the document itself. For instance, I have something here which I'll not quote directly, but a search warrant simply indicates a number of things. There's an address, there is the reasonable basis for the execution of the warrant, and it clearly shows, you must show in what is the reasonable basis in terms of the facts. When we look at the judgment arising out of the Trinidad Express in 2021, Justice C. Prasad spoke about the fact that in Trinidad and Tobago, we have not had any development of the law as it relates to warrants, and speaks to how warrants ought to be executed, and speaks to the basis for the issuance of warrants. In other words, so many cases hinge on confessions. So when police officers say, well, the man, when we approached him, said, oh gosh, boss, give me a chance. Very often that individual may be arrested on the basis he just confessed. But when you go to the court now and the police officer is repeating that this is what the man said, the position is very often the guy is lawyered up now, and he's saying, well, the police lying, and I never said that. I don't know what they're talking about. That was 5 years ago. I can't even remember saying that. So the common law decisions in Boudram and Peter Coltis and even the Guardian Media, the Trinidad Express. The ratio derived out of that is simply this, that the police officer ought to take the warrant that he has executed, and he comes to he shows the individual, this is the warrant I have here, you've read the warrant, what you said, the amount of confession, and he makes an endorsement that I entered the premises, and while searching, in his presence, I discovered certain things of evidential value, and I'm making a note of what I found. I found a fridge, a stove, USB cords, and you list out all the items you found that you believe are things of evidential value.
However, there has been a lot of complaints, if I may, whereby police would have waived the paper and not allowed the persons who are subject to the warrant to read the contents of them,
right.
and that causes a lot of contention, even as far as I remember, the Hocketa matter as well.
Right. That is another good example. The DSS situation at Kathleen Warner Drive in La Hocketa. It was said that the police didn't come with a warrant. The purpose of the warrant is simply to not only to allow one a right of entry, but to allow one to see that there's a basis for the issuing of the warrant. So if I understand your question correctly, what we're looking at is persons who are of the view that their rights are being violated in some way, that their rights are being contravened and being infringed. They can benefit from the warrant being executed in a proper way and being shown to them. Now, when you enter the premises as a police officer, you must not just wave a piece of paper in the air. You have to show the individual and give him an opportunity to read the contents of it. He must be able to see that it's made out in a particular person's names.
In theory.
Right. In theory, but it has to be done in practice.
In practice, I agree. But
and he needs to see the details of it and be able to read the contents.
Yes.
It's not just waving a document. And why it is important not to waive a document, and a lot of police officers found themselves in difficulties over the years, is they need to rely on the very same document if it is something is found of evidential value, to make the endorsement and have the individual sign that this is what we found in your presence. You see, when the individual sign, when you, Rondell Donawa, signs that when the police executed the warrant, this was found, you're signing to endorse that this is the comment I just made to the officer's boss, Isma, boss, give me a chance. So anything that hints at confession is recorded in that moment, contemporaneously, and you are endorsing with your signature. So when you go to court, you can't back out and say, well, I never said that, this is because you endorsed the document. Now, very often, what reveals, what raises a red flag in the court is when it is the police officers are saying the man confessed, but they don't have a warrant document to produce with an endorsed back of it to show that the man confessed. In other words, you can't ask somebody to endorse a document that didn't exist when you entered. So it's very often it's a hint. It's almost like if a red light is going off that you can't produce a document because the document doesn't exist. And in looking at warrants, it's a very intricate exercise. There was a recent ruling in the Court of Appeal, as recent as the 22nd of February 2022, involving one Peter Cultis. The High Court had ruled in 2004 that these warrants ought to be not only executed properly, but endorsed on the back of it and the confessions signed to. What happened in Peter Cultis in 2022 February, which is quite recently, is they enlarged the ratio in that, and they simply said that not only does that apply to law enforcement as it relates to police officers, but it applies to Coast Guards, members of the Defense Force also. So any high security or any level of security or security personnel, that endorsement and that procedure has been widened to incorporate them.
And, yeah, go ahead. Sorry.
So it applies not just to the police executing a warrant, it applies to people who confess before, let's say, the Coast Guard. And just to put it in a very wrong nutshell, the Peter Cultis matter evolved out of a guy conducting his pirogue through the Gulf Paria area there, passed just before Centipede Island. The Coast Guard saw a pirogue and they approached the pirogue. The guy sped up and he threw 2 black bags off the pirogue into the water. The Coast Guard followed him. They took up the 2 bags. They realized it contained marijuana. He confessed and said, oh gosh, it's marijuana. When it is they took him to Stourball Bay to keep him there until the police arrived, and Officer Julian arrived, and he confessed to Officer Julian that this is the position, it's marijuana, I'm sorry. So the police officer made the endorsement, but the Defense Force Coast Guards didn't make any endorsements as to the confession. So when it got to the courtroom, the issue was, why didn't the Coast Guard make endorsements when the man confessed to them before they called the police? So what the Court of Appeal said is that the Coast Guard ought to have made an entry, and this is now the law. The Coast Guards, the police officers, anybody in authority or in a position of authority over individuals, when confessions are made, it ought to be backed on a warrant or contemporaneous notes. Notes made on pieces of paper, notes made in the police station diary, notes made on your desk diary. All these notes ought to be made in order to corroborate and strengthen one's case.
Indeed. So let's say now the warrant was executed correctly. The suspect is arrested, brought before the police station in the charge room, as you call it, and they are now being interviewed, etc. How long can someone be held in custody before being charged?
Well, the law simply says this, and it's carded in the police standing orders, standing order 32. As soon as there is enough evidence in which to lay a charge, the police ought to lay a charge. An individual is entitled under the Constitutional Trinidad and Tobago Section 5 to, upon investigation, and a charge has to be laid, a prompt hearing. It means to say that you can't be kept in a station for 2 or 3 days or 4 days while an investigation is going on. And steps aren't taken to take you to court, or if there's not enough evidence to release you at the most opportune time. So, in looking at evidence and everything gathered on an individual, as soon as the law says, according to the standing order, and the Constitution, that one ought to be taken to court promptly, but it never defined whether it's within 2 or 3 days. In England, you have to justify if you keep somebody in the station for 24 hours, and you need to justify whether you need to keep them for another 24. Yes. We don't have that defined in our laws in Trinidad and Tobago. It simply leaves it very grey that you're entitled to a prompt hearing. It leaves a wide discretion in the police hands as to what is prompt. And these are subjects of debates where persons bring suits against the state.
And when we say suits, I know there are also instances where persons are kept in custody. And I know the law keeps on evolving for more than 5 days. And I know there's a specific action application one can bring to the court with respect to releasing the body, or as you said, habeas corpus. Can you just touch on what exactly that is?
An application may be done before the High Court in order for the police to bring the individual they have in their custody before a judge. And when that application is done, it's done by way of the lawyer writing to the criminal registry at the Supreme Court, indicating that he would like a hearing before a judge because one of his clients is before the police station and the police are holding for an indefinite period. Before you write to make that application to the court, you ought to write to the Commissioner of Police Office indicating that individual is, let's say, at the Caranage police station and the police is not giving you the information. If the commissioner doesn't respond, then you write to the criminal registry. Once you get a hearing, that hearing is you explain to the judge, listen, my client has been in custody for a number of days. I've written to the commissioner's office. The commissioner's office is not responding and we don't have any information why they're keeping him so long. At that point, if the judge is satisfied that there is a need to have a hearing, he writes to the AG's office, or he sends an order to the AG's office as well as to the police, the Trinidad and Tobago Police Service, Commissioner of Police Office, and they bring the individual before the court. And that is called, that in itself, that application, an application is done. And if it is the judge is satisfied that the police are not justifiably holding the individual, a writ of habeas corpus is issued where that person, an order is given that the person ought to be released because the police have not justified their reasons for holding the individual over a sustained and protracted period of time. To hold someone and detain someone without reasonable cause or without probable cause or reason in law is in itself illegal, and citizens out there have redress when police officers do such a thing. And the redress is through the vehicle or the remedy, as we say in law, of a writ of habeas corpus.
And how, in your experience, what length of time or how many days or hours does one have to be held in custody in order for the court to decide reasonably that they have been being withheld pursuant or in contravention of their constitutional rights?
There is nothing in law that stipulates that a writ of habeas corpus could only be issued after a specific period of time. The reasonable time period as reflected in case law, meaning instances when challenges were made, A reasonable time period is usually 2 days, a period of 48 hours. What ought to be done, and if anybody has any legal representation, or even if a citizen is arrested without legal representation, is upon the arrest of the individual, the family could pen a letter to the Commissioner of the Police Office, or through his lawyer pen that correspondence and indicate that the individual is being held at which station, and then indicate that we are not getting information, the police not sharing investigative material, we have no reason to believe that the individual is involved. If that is done on the first day, or if it's done on the second day, you still have to give the police in reason at least 24 hours in which to respond. And if they don't, then at that stage you initiate writing to the criminal registry and trying to get an application done through the High Court.
I mean, and this is an expensive process. So I mean, you find that most time the suspect's family unable to afford, and therefore 4 days pass, 5 days pass without an arrest.
And this is where the Legal Aid comes in. The Legal Aid Amendment Act 2012 never catered for the Legal Aid and Advisory Board providing an attorney to assist persons who may be detained in custody for reasons other than murder. And nor does it, even if there's an instance of a person being held under suspicion of committing a murder, to provide representation for the application of writs. In other words, the citizens out there have no redress in terms of a service being provided by the Legal Aid Board to address the issue of filing writs of habeas corpus. So you have to turn to private attorneys, or you try to do the application yourself. But it's
there's also this new body, this new public defenders body. Well,
the law in relation to public defendants is still evolving.
Indeed, yeah.
The public defendants provide representation in relation to if you're charged before the court and you have a matter that has to be that is going on trial, or it's a preliminary inquiry. It doesn't touch and concern the application of writs. Writs cost thousands of dollars. I mean, I can.
Tens of thousands.
It's tens of thousands. If we were to assign a value, it's $10,000 plus. So can you imagine the common man, the reasonable man out there, the average citizen having to find $10,000 upon being arrested by the police just to file a writ and you have to file a writ. You need to do it through the vehicle of a lawyer, because a lawyer has a right of audience, meaning he can speak and address a judge. A citizen who is making an application on his own could simply write to the Commissioner of Police Office asking for a response. But if it is,
of course, you know, the weight that brings with a citizen writing versus an attorney is quite low.
Exactly. But the citizen cannot go and address the court. Indeed. So at some point in time, the burden rests on the citizens that your rights are being infringed, and then your remedy or the opportunity to get redress is too costly. So arising out of these about writs and litigation, things take a long time, and it costs money. And the citizens out there don't have those kind of resources, particularly in the times that we live in.
Indeed. So I mean, I know in closing, what other advice or other statement that you can make in relation to citizens' rights when it comes to warrants, particularly, or rather police powers to just execute warrants without proper due process?
I think citizens need to bear in mind that they ought to hold the police accountable for their actions. If a warrant is to be executed at your home, insist that you be allowed to read the document. And the document, if it is not a document that allows the police to enter, you can refuse. Be sure to ask the person who is trying to enter your premises, the police officer, his name and regimental number, because you're entitled to find out who it is executing the warrant. And you're entitled to ask the whole team of officers, all the officers that enter your compound, their name and regimental, because that is important if you have to seek redress, if you need to make a complaint to the Police Complaints Authority, if you need to make a complaint to the Commissioner of Police Office. And then one has to be careful about what documents you're signing. If the police ask you to endorse a document, do not sign the document unless it is you understand the legal implications of it. Because you may find yourself being before the court with no defense. Simply refuse to sign the document until you get legal advice.
But then in that moment, that legal advice may not be forthcoming, particularly if the warrant is time sensitive.
So err on this side of caution. If it is you cannot get legal advice and the police officers are rushing you, you can't place your signature on a document and be held legally accountable for something that you don't understand the implications of what you're signing. So when warrants are executed, refuse to sign. Because signing could be the end of you in relation to your matter before the court.
Indeed, and lack of knowledge is not a defense, right?
lack of knowledge of the law is no defense at all in the courtroom.
Indeed. Fareed Ali, thank you so much for gracing us once again. I'm really appreciative, and we're appreciative of of what you have to offer. Yeah. I mean, thank you very much.
It's a pleasure to be here. Thank you.
See you next time. Right? So guys, this is a wrap. You have been watching Strictly Legal on WESN Content Capital. I'm your host. You have been with me, with Fareed Ali, attorney at law, and I will leave you with this quote. If you get tired, learn to rest, not to quit. Be blessed. Have a next day, or have a safe day. Take care.